Shara?
Good morning, and may it please the court. Jacqueline Bashara for the United States. The only issue before the court today is whether the good faith exception should apply. What's at stake is the evidence necessary to prove serious charges involving the defendant's possession of child pornography and efforts to destroy records on his phone.
No, what's at stake is the constitutional protection. The question of whether or not it's been a Fourth Amendment violation, isn't it? That's what's at stake. The merits of the case aren't, are they?
Judge Gregory, we have conceded that this warrant is facially deficient, so all that remains is the question whether the good faith exception applies, right? The
government is in an odd posture. You appear to have conceded everything away about this search warrant in order to say that it's deficient so that you can get to the good faith exception. That just seems an unusual posture to me.
Well, Your Honor, certainly I would prefer that there be no problem with the warrant. I don't like being in this posture, but I think if we look at the full picture of what we have here, the warrant, the affidavit, and the supporting documents, the best way to understand what happened here is a failure of particularity, because the affidavit is clear that they're asking for permission to search the defendant and his phone for evidence of sexual abuse of a child, and that is not properly reflected on the face of the CAS. That's a classic, all these cases that talk about particularity problems, they all have these kinds of incorporation issues, and that's really what we have here.
And the affidavit wasn't attached.
It was not properly attached.
It wasn't attached, period. You don't have to put anything in front of you.
And the government has also conceded that it wasn't incorporated into the affidavit. That's another thing you conceded, correct?
Right, we concede that under Grow, the words used on the face of the CAS are not legally sufficient words of incorporation to incorporate the affidavit. But what's important is that the commander actually had all of these documents in front of him when he authorized the search. We know that because he signed and dated all of them at the same time.
But you have another problem too, is that in terms of whether or not he authorized the search or not, because you have a finding of fact against you. The district court didn't believe that he authorized the search.
So I think
I'm reading now on page J215. I hope you're reading when you're answering my question from what the transcript says. And matter of fact, it says, I find. It starts with I find. So you have a factual finding against you. He didn't believe it. And you don't believe his standard review was incorrect, was it? He said by preponderance of evidence. Is that right? That's how he should view the evidence?
in the district court, right?
Yeah.
This court's standard of review is de
the
novo.
district court, the district court.
Right.
It's not de novo in terms of factual questions. Is it factual determinations? We go back and we can undermine that by what,
Certainly
de
not,
novo?
Judge Gregory. We are not contesting any of the district court's factual determinations. We're accepting the facts and saying that on these facts, the agent's reliance was reasonable. That's a legal question that the court reviews de novo.
Oh, but it's based upon, you said the backstop of all the errors is that, but he told me that I could search.
That's one part of it.
That's the biggest part of it that you have left because everything else was wrong. And the court found that he didn't believe it. Didn't believe it, did he? Am I wrong?
So respectfully.
Am I wrong about that? I'm not convinced by a preponderance that he said, the commander, she could search the phone. That was his factual finding. And that's a credibility finding.
I don't think that's a finding.
Are you reading the transcript? Are you looking at the transcript?
I have it in front of me, yes, Your Honor.
Did I read it incorrectly?
No.
What, you said that's not what? De novo, we look at that de novo?
The legal question.
That's not a legal question, it's a factual question of credibility. He didn't believe it. District court made it very clear by preponderance that I don't believe he told her he could search the phone. Full stop.
Okay, so if I could just clarify, there is a little bit of, we're talking about two different things. What was going on in the district court was that the government initially asserted that there was verbal and oral cast to search the phone. That's what the district court is talking about there when he says, I find that there was not by a preponderance this oral
He did
cast.
that because there was nothing in writing that could support it.
No,
It
Your
didn't,
Honor.
it didn't, it had no limitations, no affidavit was attached. The best you could do is say, well, good faith is, he told me that I could search. That's why he got to the bottom line. Everything else was wrong. It was not there. That's why, that's not out of context. That's what you were left with, really. You're saying it's good faith because even though the affidavit wasn't there, it was understated, he said that I could search the phone. The court said, I don't believe that by preponderance of evidence. We do this all. We have these suppression motions. I've never seen these cases where we said, officer said, I saw it in the glove compartment. The defendant said, no, it wasn't. I've never heard this court ever say, well, we're going to overturn that factual question on that motion to suppress and say, we believe the defendant that it really wasn't in the glove compartment. No, no, no. Why should we do it now? Because you lost.
Judge Gregory, we are not asking you to reverse the factual finding. We have conceded that there was not a proper oral cast within the scope of the military rules of evidence, okay? But what we're talking about now is, despite the deficiencies in any oral cast or written cast, whether the agent nonetheless reasonably believed that she had the commander's authorization to search the phone.
But we have to agree that the warrant was deficient in the first place, rather than the warrant said what it said, and they exceeded the scope of the warrant.
So-
That's a distinction you have to deal with, isn't it? Whether they exceeded the scope of the warrant as opposed to the warrant being deficient.
Right, so definitely that's an important distinction. I think that probably they're kind of two sides of the same coin when we're talking about particularity or execution. It's a question of when this kind of variation or discrepancy arises, right? Particularity cases, the problem arises when there's some kind of mismatch between what is described in the application and then what appears on the face of the warrant. An execution problem arises later. The parameters of the warrant have been set, everyone agrees upon them, but then something happens when the officers are trying to carry it out that causes them to vary from those parameters. And that's why I would suggest that this is really a case about particularity, not execution. But I appreciate that even if the court disagrees
But they
with me,
did
we still-
exceed the parameters of the warrant, correct?
if you think that this was simply an execution problem, then yes, but the court still has to consider whether the good faith exception applies, even if we're in execution problem world.
So is the question then, was it reasonable for Agent Smith to believe that the affidavit was incorporated? Does that become the question?
I think that's part of the analysis, Your Honor. If we're talking about execution, the courts that have looked at this have said, did the officers have an objectively reasonable belief that the warrant authorized whatever they ended up searching for? And so I think one factor the court should consider is that she thought that the affidavit was part of the cast. She testified that in her experience, all three documents were part of the cast. As I mentioned before, the commander actually signed all three documents as well.
And he said, I thought that's what I was authorizing.
Exactly,
She thought
right.
that's what she was authorizing. Now, the judge found nobody said that's what they actually said, right? She testified that, I don't remember what he actually said, so there wasn't that oral, but you have these other, what they tried to do, even if they didn't accomplish it.
Right. And then a pretty
But the
distinctive feature.
credibility, it was found against you.
The district court made no credibility findings,
He
Your
did
Honor.
make a credibility finding. They testified that she said it was his understanding verbally that it would include the search. He said he didn't believe it. He didn't believe that about preponderance of evidence.
He
That's
said
what he was talking about. You can't change that. The record is the record. I don't know why the government is pressing this case, I guess, in the sense that you lost, like you normally win most of these cases, but here the district court found against you in the credibility.
Didn't he say Agent Smith, quote, was very candid? She couldn't remember, and I doubt he could either. So I'm not convinced by the preponderance that he said she could search the phone. Is that what we're
Yes.
talking about?
That's right. So
Well, how does that help you? I mean, you can't remember, that means it's good? It's strong evidence? Where's
Because-
the evidence?
Because when we're talking about an oral cast under the military rules, it has to be some kind of express authorization, and the problem is that her testimony and the commander's testimony that it was essentially
That's
conditional.
no different than it is in the civilian, is it? It's supposed to be in a warrant. That's what the frame was at. The warrant is important because that sets the framework and where we can overcome what otherwise is a constitutional protection to say we can go to your person and your property and search it. That allows to have that, it's not just a, but the warrant is important.
It is
that's part of-
important.
Right, and it's very important. And there's no affidavit, there's no limitations. And then they
Respectfully,
come
your-
and said, and the court said that, again, I'm just reading, I'm not convinced, but upon that he said that she could search the phone because that's what he testified to. Didn't
Right,
he?
she didn't have a
Didn't he
proper-
testify that he did, that she said, he said that to her? Did he testify that he said she could, he told her she could search the phone?
Yes,
And the court did not believe that by preponderance of evidence. Is that right?
yes,
Thank you.
And if you admitted that in your brief, that you're accepting there was no
Yes.
oral authorization, and your argument is good faith, right?
exactly.
So when there's a Fourth Amendment violation, that doesn't actually solve the question,
Right.
right? The Supreme Court's told us exclusion is the exception, exclusion is not the rule.
Right.
So what's
That's-
your argument on good faith? Why it was objectively reasonable to believe that they had authorization to search this phone?
Because throughout this process of applying for, obtaining, and actually executing the CAS, everyone understood that the purpose of this was to search the defendant's phone for evidence of child sexual abuse. We've talked a little bit about what happened before they actually met in writing, or I'm sorry, met in person and signed the written documents. When they met, the commander put her under oath, and she swore to the written CAS, and he signed these documents, and the attachment is quite specific about what they were going to do with the phone,
They were
right?
going-
Which is not incorporated into the warrant.
It's not properly incorporated, Your Honor, but it is something that the court considers in assessing objectively
No,
reasonable
the good faith
faith.
exception doesn't apply if they exceeded the scope of the warrant, does it?
We don't agree with that, Your Honor.
Based on what?
Well, it comes from the Supreme Court's decision in Maryland versus Garrison, which was an execution problem, and there the court did consider whether the officers objectively reasonably believed that they were executing the warrant properly. That's how other courts of appeals have treated this issue in published opinions, like the Seventh Circuit in Grisanti, the First Circuit in
Would every
Pimentel.
warrant that authorizes a seizure but not a search be insufficiently particularized under your analysis?
Again, I think it depends on sort of where is this variation occurring?
Well, then how?
Is it in the request, the application? Is that where the sort of discrepancy arises? Or does the discrepancy arise later, for example, where, they've got the wrong apartment number and then they're trying to execute the warrant? And we haven't talked yet about what happened after the commander signed the CAS, and I think that's pretty important to the court's analysis. It's unusual that the forensic examiner who had the written CAS in front of him actually stopped the search because he understood that there was a parameter defined in the written CAS to
He
search for.
understood that they were exceeding the scope of the warrant.
He was concerned about that, and so that's why he stopped the forensic examination and came back to Agent Smith and said, I think we need additional search authorization to search for evidence of possession of child pornography.
So
And
he
just
was
to-
acting as though the affidavit and its attachment were incorporated and were part.
Yes, exactly,
of the
and in
warrant.
that respect, this case is a lot like this court's previous decision in Kazaa. That case involved the wrong attachment B listing the items to be seized that was attached to the actually signed and executed warrant, but this court upheld the application of the good faith exception, notwithstanding that the warrant was facially deficient. And the court's reasoning was essentially this document assembly problem in that case. It didn't affect the
That
magistrate's
case is
determination.
totally in opposite of this one. That's the case you mean that they attached, stapled, the affidavits were there, they just stapled it to the wrong one. Is that what case you're talking about?
That's the one I'm talking
Yeah,
about.
that's
They
different.
attached.
You don't have anything to staple anything. You didn't have, the warrant is just, there's nothing there.
Respectfully,
And
Your
if that's the
Honor.
district court, no, with respect to the district court, you know, we always talk about, the district court saw this case. I mean, the things you conceded, you agree that it's the defective,
Right.
right? And you try to, I mean, you're smirking, seeming to me, but what you seem to me, what you're saying is that all this is cured because someone in the laboratory saw what? Saw an affidavit and said, we've gone too far, but they were already searching the phone by that time, weren't they? Were they
I see
not?
that my
Weren't
time
they?
has expired.
I
May
know
I
you are,
respond?
but I'm asking you the question, so you okay.
Okay. Our position is not that these documents cured the defect in the CAS. That's a separate question, right? That would be before you get to good faith. We're not there anymore. Now we're just talking about the good faith exception, and that's where the court looks at all the facts and circumstances of the case. If I may just explain why I believe that the Kazaa case is helpful here, it's because the court said that problem, attaching the list of items to be seized from the wrong defendant's house, it didn't affect the magistrate's decision to issue the warrant, and it didn't affect the ultimate execution of the warrant. That's exactly the same circumstances here, right? We know that the failure to properly incorporate these supporting documents into the face of the CAS, that didn't affect the commander's decision to issue the CAS, and it didn't affect the forensic examiner's ultimate execution of the CAS.
Well,
And so-
when he signed it, he thought it was maybe just for the seizure, because that's what it said, didn't it? To
That's not
seize.
consistent with his sworn testimony.
Well, that's the problem you have. Who believed it? I mean, what part of it was believed that was relevant? I'm just in the findings. Okay, very well.
I
Go
have
ahead.
one
That's
question.
fine.
You mentioned a Supreme Court case earlier. What was the name of that one?
Maryland versus Garrison?
Maryland versus Garrison. Okay. I was looking for it in your brief. Is it in your brief?
I believe it's cited by either
Maybe by...
Pimentel or Grisanti. It is cited in our brief.
Okay, thank you.
It might be in the reply, perhaps,
Okay.
Judge Thacker?
Thank
Yes.
you.
Okay, thank you.
Thank you, counsel. Mr. Rayfield?
Thank you, Your Honors. Mike Rayfield on behalf of the defendant Joshua Ray.
Can you either move the microphone closer or speak up?
Sure.
Please.
I want to start with the point about the factual findings and then turn to the point about the distinction between execution and particularity. So on the factual findings, I think, Judge Gregory, I agree with you. Because Ray's motion to suppress was granted, this court reviews the evidence in the light most favorable to him. And the district court didn't just draw the ultimate conclusion that the good faith exception doesn't apply. It also made factual findings that can't be reconciled with the government's position. And the big example, as we've been talking about, is the testimony that Commander Washburn told Agent Smith that she could search Ray's phone. The district court rejected that testimony in the quote we've talked about a few times. Now, the district court didn't make a factual finding on every single piece of testimony that was offered in the suppression hearing.
So do you agree that the district court didn't cast out the commander's credibility entirely?
I don't think expressly, but I think by implication.
That
Because
the court said, it's very possible Commander Washburn thought he was talking about searching the phone.
But then on the same page, the
Right,
district
but
court
that
goes
said he
on to
didn't
say.
actually orally authorize it.
Right.
That's a finding. We
That-
can't
that-
disagree with that unless it was clearly erroneous.
That's fair, but I don't think there's any indication that the district court found any of the testimony credible. I mean, to the contrary, he told Agent Smith at one point that her, quote, obfuscation of the record was, quote, just unacceptable. And because the government hasn't argued that anything was clear error here, I'm not even sure the court can accept any of the testimony given below as true.
Is the question for us, though, whether it's objectively reasonable? It's not really who believed what, right? The legal question is, was it objectively reasonable to believe that Agent Smith had authorization?
Well, let me move past the factual findings into the distinction between execution and particularity. So the Supreme Court hasn't applied so far as I'm aware, the good faith exception to a situation like this one, where an officer exceeds the
Well,
clear limits of
I
a
Well,
did-
lots of courts
did-
haven't they? Don't we have other courts of appeals where there's an incorporation problem, where an affidavit authorizes something, but the words in the warrant don't incorporate it, and all the other courts of appeals have asked, can you in good faith believe that was incorporated? And you can. So, I mean, isn't there actually a lot of precedent going that way?
I would respectfully disagree with that. I
Oh,
think
okay.
in all of the cases the government cites, as far as I'm aware, there was a defect in the warrant itself. There was a particularity defect. It wasn't.
And is that the same for, so I did find the Maryland versus Garrison case that opposing counsel cited in her reply brief. Do you have a response to that Supreme Court case and its applicability here?
Honestly, I don't. It wasn't, I think it was in
Right,
a
it's-
quoting site.
It's in a quote of a quote
Yeah,
sort of
so
thing, but
to be honest, I haven't prepared a response to that, but I'm happy to follow up with a letter on that case, because I just don't know the case well enough. I apologize for that. But as far as I know, the Supreme Court has never held, in all of those cases you were citing, Your Honor, in the out-of-circuit cases, there was a defect in the warrant. So the officer is actually reading the warrant and abiding by its terms, but there's a problem with the warrant itself, a particularity problem. What we have here is an execution problem. The CAS allowed Agent Smith to search Ray's person and seize his phone. No reasonable officer, I would say, could read that and think that it allowed a search of the phone. And in that situation, Leon's good faith exception has no role to play. Leon itself says that its exception applies when an officer acts in, quote, good faith reliance on a search warrant that is subsequently held to be defective. The court went out of its way to clarify that the exception, quote, assumes, of course, that the officers properly executed in the warrant. And that makes sense, because when officers exceed a valid warrant, unlike where they're, objectively reasonably carrying out a defective warrant, the blame for that constitutional failure lies entirely with the officer, the very actor that the exclusionary rule is designed to deter. And I want to point the court to a case cited in our brief, which I think is almost directly on point. United States versus Angelos. It's a 10th Circuit case, 4033 F3rd 738. In that case, the officer asked for authority to search for a variety of items in a house, but the warrant itself only allowed the officer to seize a subset of the items requested. The officer then went beyond that limit. It was an execution case. The 10th Circuit held that, quote, the good faith exception will not save an improperly executed warrant. And it continued.
Well, here, here you have, they asked for permission to search the phone and get very particular things from his calendar and his photos and his thing, and they were given that authorization in an affidavit, an attachment, signed, but it just wasn't, the words weren't properly used in the warrant to incorporate it. It referred to the affidavit, but it didn't properly incorporate it. That seems a little different, where you have authorization, but the problem is a disagreement about whether the warrant included all three of these documents or not.
I respectfully disagree that there was authorization. They certainly requested authority to search the phone. I don't doubt that. But the warrant itself is the document that gives authorization, and there's no possible reading of the CAS that allows for a search of the phone. And to be clear, the written warrant itself is critical, because that's what's actually presented to the arrestee. It's the document that, as to use
When you're
Groves-
talking about deterring the right people, right, the agent and the person in the magistrate's position here, both of them knew about and were on the same page with all three of these documents. So where's the deterrence problem that we're trying to solve by excluding the evidence here?
The deterrence problem, I think that the Supreme Court's cases say repeatedly that the exclusionary rule is not so really about deterring the issuer of the warrant. It's mostly about deterring, if not all about deterring the officer. And the deterrence value is huge. At minimum, we want to give officers the incentive to read warrants and abide by their clear terms. The
Yeah,
government's
that
position,
seems reasonable, that they would read a warrant before they executed it.
I think that
Well, he or
that's,
she did, right? She read the warrant and the affidavit and the attachment, all of which she thought were incorporated. And so doesn't it, again, come down to whether it's objectively reasonable to believe that the affidavit was incorporated?
well, I think that the premise of that question is contrary to what the district court found.
How's that?
Because the
And
district,
Isn't it also contrary to what the government has conceded, that the attachment wasn't incorporated?
yes, I mean, I think that
Can we agree that there's a fact not incorporated? And then there's a legal question, was it objectively reasonable to believe that it was, even though it wasn't incorporated? And those are different questions.
It was not, right, so there's the government concedes that the attachment was not legally incorporated.
Right.
And I think what you're saying is.
And the court found that as a fact it wasn't,
Right.
and it's, as a legal matter, the magic words were not used to incorporate it. It refers to the affidavit, but it doesn't say we're incorporating for searching everything that's in the affidavit, right? That didn't cut it. But my question is, doesn't the question become for us whether it was objectively reasonable for an agent in Smith's position to believe that it was incorporated?
No, for two reasons. One is that the district court did not, I don't think, like for the reasons I was saying before, I don't think it's fair to accept, even accept Agent Smith's testimony on that point as true, that she believed that the affidavit was incorporated, because the district court rejected a core piece of her testimony. And so,
But wait, I guess I have two questions. One, what is the core piece that matters? And two, why does it matter? It's not a subjective inquiry. This is an objective question. Would a reasonable officer in her position have thought that they had authorization to search the phone for the things listed in the affidavit?
right, but I think I thought that, I apologize if I'm misunderstanding, but I thought that the premise of the question was that she actually did believe that that she had authorization based on what she thought was an incorporation, and that's the piece of it that I don't think can withstand the district court's factual findings, because Agent Smith testified, I got this authorization from Commander Washburn, and the district court said, I don't find by preponderance of the evidence that you have.
Well, the district court said, I don't find by preponderance that he said that. Again, that's the oral authorization, but the court, the paragraph above, said it's very likely they both thought they were talking about searching the phone, right? And that's fine, and we can accept that factual finding. We don't have to overturn that. We are asking a legal question of, was it objectively reasonable? Would a reasonable officer in her position have thought it was incorporated?
Okay, so I'll return to the legal question, and as a matter of law, the answer is no, because the Supreme Court has never held that if you exceed the scope of a valid warrant, regardless of
But
what.
that goes to the question of whether you're exceeding the scope. Do you see why? The whole question is the scope of the warrant, does it include the affidavit or not? That's the question. And so this debate about, is it facially defective, is it not, it all comes down to, was it reasonable to think that the warrant included the affidavit?
Okay, I'll answer that. The answer is no, because because the CAS itself, the document that grants authority, is a standalone document. It said on the document, page 1 of 1. There was nothing attached to it, as Judge Gregory pointed out. Agent Smith should have known, and an objectively reasonable officer should have known, that if a warrant says you can search a raised person and seize the phone, regardless of what you're asking to do, if you don't actually get that authorization in the warrant, it's not objectively reasonable to search the phone.
The government claims that Smith and the NCIS examiner stayed within the parameters of the affidavit and the attachment. Do you agree with that, or do you dispute that?
I think that they stayed within the parameters of the affidavit. They exceeded the CAS twice. I think that's That's a critical point, and
Right, but
my
that they,
friend-
I guess my question was just, I wanted to make sure I understood your position on whether they, so they did not exceed the affidavit and the attachment.
I
They
agree with
treated, and if those were incorporated, then they stayed within the warrant. You totally disagree with the premise that they were incorporated, though, right? Or that it was objectively reasonable to think
that
they
it
were.
was objectively reasonable, right. But I do think that that's an important point, and it goes to a point my friend made about what Agent Smith had done in the past, because this wasn't an isolated incident, and that's important for deterrence too. Agent Smith testified that she had been the affiant for 25 warrants, or in her time in the NCIS, and every time she treated the CAS, the affidavit, and the addendum as the CAS. In other words, she was operating as though her request for authority was the equivalent to a grant of authority. So who knows how many other constitutional violations she had committed. I don't want to
And what
speculate.
was the authority? Was there authority introduced to, in this particular context, about the regulations and what qualifies and what does qualify? I thought there was something that, it didn't say that's wrong, but it also didn't say that's right. Can you remind me?
I'm sorry, I'm not sure. Are you talking about the
The
military?
the Quickman, Navy Commander's Quick Reference Legal Handbook?
You're referring to the military handbook?
Mhm.
As far as I'm not sure of the question. I'm sorry.
I thought there was some evidence about whether she was right or wrong about how she considered these documents, whether they all are part of the CAS or not.
I don't. Right. I think what you said is right. That the handbook did not say one way or the other whether these documents are all part of the CAS. But the government agrees on appeal that they're not all part of the CAS. So I mean, I think that it's difficult to parse things between what she, if we're in the world where the district court rejects her testimony about what she believed, and we're also in the world where we're trying to figure out what an objective officer who believed something would think. I think that we can't get past the district court's findings of fact in that respect. Now, if the question is just, would an objective officer generally conclude that these are all the same document? I think the answer is no. It's important that officers have an incentive to get warrants right, to have an incentive to write them out properly. She is the officer who is actually preparing the CAS, which is important under the Supreme Court's decision in Grow. And there's just nothing in this CAS that would suggest that she had authority to search the phone. And again, I want to just emphasize again, the written warrant is what is actually presented to the arrestee. It's the document that gives the arrestee confidence that the officer actually has lawful authority to conduct the search. Otherwise, the arrestee could create misconduct, could disagree and sort of resist the search. And that's why the warrant requirement is right there in the Fourth Amendment's text. So unless the court has any other questions, I don't think I need to use more time.
Thank you. Very good. Ms. Bashara, you have some time reserved.
Just 2 points in rebuttal. The first, my friend suggested that the cases that we cited about execution don't actually involve an execution problem. Respectfully, I disagree with that contention. Grisanti and Pimentel both involved claims that the officers exceeded the scope of the warrant, and in both of those cases, the Seventh Circuit and the First Circuit, applying Maryland versus Garrison, looked at whether the officers had an objectively reasonable belief that the search they conducted was within the scope of the warrant. The second point I would make, Judge Rushing, you asked about what deterrence value does this have? Ultimately, the mistake here is not that the documentation was insufficient to support this cast. It's that it wasn't properly incorporated. And there's not real incentive for officers to conduct a thorough investigation and prepare these detailed documents and then fail to properly incorporate them. I mean, they have every incentive to make sure that their warrants are sufficient to
Well, the
avoid risking
document that
suppression.
should have properly incorporated is one page. It's not detailed. All they needed to do was add one sentence.
Right, and that's just a drafting error. So
Pretty critical one.
it is, and that's why we've conceded it's insufficient, but it's not the kind of culpable misconduct that the Supreme Court has said is necessary to justify suppression.
You say the Supreme Court said it has to be a culpable?
Yes,
Culpable?
yes.
Right. What Fourth Circuit case did you cite? In the Supreme Court case?
That comes from Herring and from Davis.
So
But
in
of
other words,
course-
you have to find wrongdoing to get, did you say wrongdoing?
It has to
Culpable
be
is
some
wrongdoing.
kind of more than mere negligence. It has to be culpable misconduct.
Culpable is different now. Culpable is it's worse than sort of extreme negligence, right? Culpable means it's-
Right.
That's
And
a
that's from
mens
the
rea
Supreme-
type, almost bad acting.
Yes, Your Honor, that's what the Supreme Court has said.
Well, I mean, I think you could find extreme negligence in drafting a one-page document and not getting it correct.
Respectfully, Your Honor, there's no suggestion in the record that Agent Smith was sort of aware of this problem and just kind of
I
flagrantly
know, that's the
disregarded it.
problem with her negligence and incompetence.
But at most, it's mere negligence, and that's not sufficient to warrant suppression.
But that's if we get beyond this exceeds the scope of the warrant, right? That's if Leon's applicable at all. We're talking about the exclusion and whether there would be any deterrence value. If Leon is applicable at all, that's where we are.
Yes, that's correct, Judge Thacker. Unless the court has further questions, we ask that
And you do agree that all inferences are drawn in favor of the defendant here?
factual findings, yes, Your Honor.
Yeah. Okay, all right.
Okay, we ask that you reverse. Thank you.
Thank you so much. I think both counsel will come down and greet you both, and then we'll proceed to our final case of the term. Mr. Leary, are you ready?
Thank you, Your Honor. May it please the court, Brendan Leary for the appellant, Mr. Walton. We're asking the court, we've raised 3 issues in our brief. The first one was whether the sentence that was imposed by the district court is plainly unreasonable, and we argue that it is for 4 reasons. The first one is the fact that the district court never reviewed with Mr. Walton, who was proceeding pro se, the violations in the petition. And it was a lengthy petition followed by another lengthy amended petition that added an additional charge. And although Mr. Walton advised the district court that he wanted to proceed pro se, we are arguing and think that the district court, the better course would have been for the district court to have reviewed each one of them. I think that the petition and the amended petition were a little confusing. And I think that that would have obviated some of the problems that occurred after that with Mr. Walton clearly during the hearing talking about he was guilty of the charges that he pled guilty to in state court in Kansas. And there was no discussion about a potential charge or a charge that had potentially been filed in West Virginia and these other matters. So we think that if the district court even...
I thought maybe the government brought those up, the West Virginia charges in the hearing. Is that right?
I don't recall, Your Honor, if the government, maybe Ms. Conklin did refer to that when the district court at the end of the hearing gave the government an opportunity to speak. I think that when it comes to the procedural problems, that the district court taking Mr. Walton at his word when he was proceeding pro se, I think would have been, that in our view is procedurally unreasonable. It would have been the better course to review each one, because then that leads us to the next problem, which was the actual calculation of the guideline range under Chapter 7, and the court must take into account the Chapter 7 policy statements. And one of the things that the court has to do then is consider the advisory guideline range under Chapter 7. Well, that necessarily requires then the district court to determine what is the violation grade A, B, or C. And there's specifics with regard to how a violation is graded. And we believe that the district court was proceeding with the assumption that it was a grade A violation. If you look at what Mr. Walton said during the course of the hearing, he believed that it was a grade B violation. And the distinction is important because the guideline range for a grade A violation, I believe, is 51 to 63 months, whereas the grade B violation, I think, is 21 to 27, but it's a significant difference. Mr. Walton believed that he was pleading or had violated a grade B violation because the charge in Kansas that was originally charged, and that was in the first petition, maintained that it was a controlled substance offense. Several months later, when Mr. Walton pleaded guilty in the state court in Kansas, he pleaded guilty to a reduced charge, which was transporting drug proceeds. That doesn't make it a controlled substance offense under 4B 1.2.
But weren't there two listed in the documents that he got? There were two grade A violations?
Yes, Your Honor, there was. And that next problem was that based on the investigation when he was stopped in Kansas, there was some communication between the police department in that county and the Ohio County, West Virginia authorities. And evidently, a state trooper in West Virginia filed a criminal complaint in the Ohio County Magistrate Court. Those documents were never attached to the petition. The only thing that the probation officer put in the amended petition is this discussion, interestingly, about the West Virginia charges, not from the West Virginia charge, where they could have easily just gone down the street and gotten the criminal complaint. It was referred to in the police documents from Kansas. So yes, there were two alleged A violations. There was the first charge in Kansas, and then the subsequent charge in West Virginia. We argue, though, that even had the district court reviewed those with Mr. Walton, that the West Virginia charge wouldn't have been a grade A violation either, at least at that stage, because he was charged, we think, although I've never seen the documents, with possession with intent to distribute marijuana. Under West Virginia law, if it's charged in the magistrate court, it can't be punishable in excess of a year. So that wouldn't be that wouldn't have been a grade A violation either, because that charge wouldn't meet the definition of controlled substance offense under 4B 1.2 either. So all of these questions that we have could have been obviated in our view if the district court had read the violations to Mr. Walton, even over his objection, because the transcript's clear, and I was sitting there, and Judge Bailey asked him if he admitted to the violations, and he said yes. So he further asked Mr. Walton if he wanted the petition read to him, and Mr. Walton said no. But I think the subsequent confusion in the hearing and what he talks about is when he says something to the effect of, well, I did that out in Kansas, and I just did that because the police department wanted to seize the money, and I just wanted to come back to West Virginia to face these charges. So there was no grading of the violation. There was no determination of the advisory guideline range. And then the fourth issue that we think was a big problem here is that the district court, when it imposed the sentence, which is the statutory maximum of 60 months, never explained the sentence in any way. The district court just simply said, I find you violated, and I impose that you're committed to the custody of the Bureau of Prisons for a period of 60 months. And
Did
that was
Mr.
it.
Walton argue for any lesser sentence or different sentence? Did he make any argument on any of the factors for why it should be different?
I don't think he did, Your Honor. I think he was more involved in this Surratt case, that he wanted to preserve the error for that. And I think, knowing Mr. Walton as I do and his history, I think that he was puffing with the district court and trying to convince the district court that he was, one of these experienced and all-knowing jailhouse lawyers.
So there weren't any arguments from the defendant that the court needed to respond to?
In terms of the precise sentence to impose, no, I don't think so.
And that's usually plain error. I know we're already plain error, I guess, when we're in the revocation, but we're a different brand of it, I guess.
Correct, and we think that the fact that the district court never explained anything was a plain and obvious error. So the procedural errors here.
Well, the court did, don't we have to take, there wasn't much said, but don't we have to look at the whole context, right? And the court said this is what your 4 convictions, 4 federals, you've only been out of prison about 6 years your whole adult life, and you don't, quote, you don't really give an indication of stopping.
And Mr. Walton agreed. And then
Well, the
started
court
talking.
told him you don't have to answer that last one, right? The court said you don't have to agree with the
Well,
last one.
He started talking about bribing more jurors or something. to
I'd
this
bribe the
effect.
whole courthouse if I could.
Thank you, and that's right. So, but in terms of the precise sentence, Mr. Walton never actually said, well, Your Honor, I think that I should get 27 months here, or I should get something significantly less than 60 months. But the district court did review that, and I think that Mr. Walton has quite a history in the courthouse in Wheeling, going back decades, and doesn't take a historian to understand all of what happened with his underlying case and his subsequent commutation. So I think the district court, I think, was familiar with his basic history, but in terms of explaining why he did that and why the sentence was imposed, I think that all occurred before the district court imposed the sentence. And the district court didn't say to the effect of, and I'm imposing this sentence because, and as this court has made clear, it doesn't have to be a very long litany. It just has to explain why the court imposed the sentence that it did. And the district court never did that. Which leads me then to the second issue, which kind of dovetails to the, from the first, which is this pro se colloquy, and the fact that the district court didn't do anything other than say, Mr. Walton, you want to go pro se? And I think, again, he was confused because he said, I'd like to go pro se, and I think he said standby counsel. And if you'll read the transcript, you can tell that I had talked to the district court judge about what my role was, because I was a little unclear as well. And I think that the district court was required, or we think that the district court erred when it didn't have a more robust and descriptive inquiry about his ability.
But before the hearing, appellant filed a notice of his intent to proceed pro se and also had his appointed counsel file a notice of his intent to proceed pro se. So prior to the hearing, there were 2 instances where he evidenced his intent to proceed pro se. So the hearing would be the third time.
He filed a pleading requesting to go pro se. Interestingly, in that pleading, I think, again, supports our argument about reading the violations and advising him in open court on the record about the significance and the implications of going pro se, because in that pleading, he talks about he pleaded guilty in state court in Kansas to a grade B violation. And then that makes sense that at the hearing, when he says, oh yeah, I did that out in Kansas, I pleaded guilty out there. So he's a very intelligent man who has spent decades in prison in the law libraries. And there's no doubt that Mr. Walton understands the legal process. However, that doesn't necessarily indicate that he completely understood how the revocation worked. He's never been, after 30-some years, this was the first time he'd been released and was now on supervised release. So he did ask in the pleading for the district court to permit him to go pro se. But again, I think there were some errors in his logic in that argument. The government, in its response brief, said that they think that the standard of review on the second issue about permitting him to waive his right to counsel is an abuse of discretion. And we argued that it was a de novo review. I don't think this court, and I could stand corrected, has held that in a revocation context that the standard of review for the district court granting somebody the ability to go pro se is an abuse of discretion. If this court adopts that, then we believe that either way, either under the abuse of discretion standard or under the de novo review standard, that the district court didn't appropriately do what it was supposed to do here. And the government has cited some briefs from some cases from some other circuits. And if you look at what the district court in this case did, compared to what the district court did in some of those cases, and the one in particular is the Boltinghouse case from the Seventh Circuit, the district court judge in that case, at a revocation hearing, explained the violations to the defendant, went through them with the defendant, had an extensive colloquy and asked him questions about did he understand the significance and consequences of going pro se. And in fact, I believe in that case, the district court in the Boltinghouse case urged the defendant not to go pro se. And that's in stark contrast to what the district court in this case did, which was one sentence: do you want to go pro se? And we think under an abuse of discretion standard that wasn't enough, that was an abuse of discretion, even though it's maybe a different standard of review.
Are there courts that have, I take your point that those courts have applied abuse of discretion. Are there circuits that have applied a de novo review to the pro se counsel question in a revocation
Not that
hearing?
I'm aware of, Your Honor. I only have a few seconds left. We would just simply rely on the Surratt, the argument in the brief about the Surratt opinion. Mr. Walton was very animated at the revocation hearing about preserving that issue, and we've just quoted the concurrence from Judge Wilkinson in that case, and are asking the court to find that the district court didn't have jurisdiction once the presidential sentence was commuted. I'm out of time. I'm happy to answer any additional questions.
Thank you, Mr. Leary. Ms. Conklin?
Good morning. May it please the court, my name is Jennifer Conklin and I represent the United States. This is a very unconventional defendant in an unconventional hearing with very conventional violations. This defendant, as the record reflects.
Violations by whom?
I'm sorry?
You said violations, the judge's violations, or who?
Violations by the defendant.
Oh, you mean charge? Okay.
The supervised release violations.
Okay.
Yes, and it was an unconventional hearing. As the court can tell by reviewing the transcript, Mr. Walton is a very animated person, and he is very headstrong, and when he wants to do something, he does it. And I'm sure the court can notice that from just reviewing the transcripts of this case.
Well, could you start with the grade A violations? grade A violations.
Yes, Your Honor.
That finding, was that correct?
There were 2 grade A violations in the affidavit.
Right.
The court never specifically went into classifying what the grade A violations were.
Isn't that error? I mean, that's what if you're there for a revocation, that's a big deal. Isn't it a grade A versus B versus C? I mean, that is like,
Your Honor,
that's quintessential. I mean, so that's,
and in this case, Your Honor, again, this is a very unconventional hearing and very unconventional defendant.
you said that, but, you know, we try to have conventional proceedings in federal courts. So what I'm saying is that was important to get it right. That the grade is like the charge. It's like going and say, well, you're charged with this, but we're not gonna figure out what your maximum sentence is. Was that properly, did he have grade A violations?
Yes, Your Honor, he did have grade A violations.
That's
He
what I want
did-
you to explain, to respond to Mr. Leary. Mr. Leary
He-
said it was not.
He had a grade A violation because he was charged in West Virginia court with possession with intent to distribute marijuana. And that's actually referenced in the violation, the affidavit of violation at page 93, where it specifically says that charges were pursued in the state of West Virginia, in Ohio County, West Virginia, for possession with intent to distribute marijuana. He was found with 13.5 pounds of marijuana in his residence. And I think,
But that's not the end, though, is it? It has to match whether or not these are qualifying convictions, right?
no, Your Honor, but I think what we have to, I think the thing that's
I want you to
important.
respond to Mr. Leary's argument. It was very specific. He laid out in his brief and everything. He said that these didn't match in terms of you matched them. It has to be certain.
And
whether or
actu-
not, in fact, I want you to respond.
Actually, Your Honor, they do match.
They do match.
They do match. If you look
Because
at.
it's marijuana?
Your Honor, if you look at the 5 new law offenses listed in the affidavit, and when you review the factual recitations within the affidavit, it says 5 new law violations. The first is speeding in Missouri. The second is unlawful invest in an item intended for drugs, speeding and display of a license plate from Kansas. The 5th violation, or the 5th new law violation, is West Virginia possession with intent to distribute marijuana. And those are the specific 5 law violations that are pending against the defendant, and that's the actual order that they're expressed in the affidavit on, it would be JA 037, where it talks about new law violation, the first 4, I'm sorry, 1, 2, 3, 4, 5 new law violations, the mandatory condition that he shall not possess controlled substance in violation of a condition of supervision, number 1. So those first 5 are the first 5 violations that are listed in those 4 paragraphs, starting with the first offense was the Missouri Highway Patrol speeding. That's the first line of the affidavit. So they aren't explicitly stated new law violation, speeding, but if you actually track the actual language that's in the petition, that it matches up with the type of violations as well. So if you reference at that point the violation worksheet, commission of a new offense, speeding, C, and then you match up the other violations when you get to commission of a new offense, which would be the West Virginia possession of 13.5 pounds of marijuana with intent to distribute, that would be an A violation,
And it's an A violation because of what?
because it's a
Because
controlled
marijuana?
substance.
Because it's a controlled substance.
Yes, Your
Period.
Honor. Punishable by more than a year.
Was it
Yes,
categorically?
yes.
Well, counsel says not. It said-
If he was charged with misdemeanor possession of marijuana, but that does not appear to be what he's charged with. He's charged with possession of marijuana with intent to distribute.
And he was convicted of that?
No, Your Honor, he was not convicted of it. He was charged with it. He wanted to come to Northern District of West Virginia and make his Surratt argument, which is, again, what he said in the transcript, which is why he wound up just pleading and forfeiting all his money in Kansas, because he wanted to get back and make the Surratt argument. In this case, Your Honors, I believe you have to look at the totality of circumstances and the totality of the hearing. I believe that the court was very concise with what the court had said. The court didn't specifically say a whole lot of things about this defendant, but he did say, as I look at it, you've been out about 6.5 years since you were 26 old. The court also said you don't really give any indication of stopping. You don't have to answer that question. And based on Mr. Walton's admissions, it's a judgment of the court that defendant is remanded to serve a sentence of 60 months. The other thing that's important, I believe, to look at in this case, Your Honor, is that the charges that the defendant was sentenced to life in prison initially for, conspiracy to distribute marijuana, aiding and abetting in possession with intent to distribute marijuana, and then the other convictions that he received at the time, which was interstate travel to aid in racketeering and money laundering. That's the exact same thing that he was doing when he was arrested this time and when this supervised release violation took place. And I believe that looking at the judge's statements, that's what the judge was aware of, the defendant's history, in Mr. Walton's history in the Northern District of West Virginia and Mr. Walton's behavior. The question is, was the sentence reasonable? And I submit that it was reasonable. In this case, the defendant, Mr. Walton, received written notice of the violation. He received a disclosure of the evidence against him. He received, as my friend stated, the affidavit was quite long. The affidavit was quite long because there were so many police reports that were attached to the affidavit. Mr. Walton was given the opportunity to appear, to present evidence, and to question an adverse witness. He was advised of his right to retain counsel, was actually appointed counsel in this case, and rejected counsel because he wanted to make sure that the argument that meant the most to him, that he believed was most important, was made. And he was given the opportunity to make a statement and present evidence and mitigation. So the rules of criminal procedure have been met. The question is, can we look at the transcript? Can we look at the record to see that the court did what it was supposed to do? And I believe when you look at the record as a whole, when you look at the totality of the record as a whole, we can see that the court made its findings and the court made its decision and the court made its sentence for specific reasons. Should the court have gone through more of a colloquy with Mr. Walton about his right to counsel? Well, maybe that would probably make it much easier to review on appeal. But Mr. Walton is a person who presented his CV basically to the court, advising the court that he has represented hundreds of people. He's gotten people, clemency, not just his clemency, but other people's clemency. That he's very familiar with things and that he spent his entire 30 years in custody in the law library. So this is not your basic generic defendant that's presenting before the court. The other thing is, when an individual makes a statement in court, we need to take that individual statement for what it is. And in this case, the judge asked Mr. Walton, have you had the opportunity to review the affidavit? He said he did, and we need to take his word at face value unless there's something to say that he's misrepresenting things to the court. But it's not just Mr. Walton's statement in court saying, yes, I've read the evaluation or read the affidavit, yes, I accept it. But it's the written pleading that he filed before the court, that he asked the court that he wanted to proceed. He stated that he understood the maximum that he was facing was 60 months. He disagreed with the Kansas being a Class A or a Grade A violation. But that indicates, all that together indicates that Mr. Walton knew what he was doing and purposely was choosing to go forward a certain way. And that's information that the court can consider in deciding, whether he needs to go through a fuller colloquy with Mr. Walton and how to proceed from there. Does the court have to methodically tick through Chapter 7 policy statements and considering the applicable 3553 factors, Section 3553 factors? And I submit no. In this, in the previous cases before this court, it stated that the court doesn't have to methodically tick through the different factors that the court has to consider. In this case, I think it's clear that the judge sentenced the defendant based on Section 3553, subsection A to B, and subsection C. The sentence was made to afford adequate deterrence and protect the public. I think that's something that's easily interpreted from the court's discussion of Mr. Walton. As far as Mr. Walton's self-representation, it would be a very different question that we would be addressing here if this was pretrial. But post-sentencing, the defendant stands in a different place, basically. There's already been a determination that the individual has violated the law. And there's less of a concern that his basic rights are protected. A revocation proceeding is a modification of a previously imposed sentence. It is therefore not a critical stage of the criminal process. And the Supreme Court has declined to state that there is a constitutional right to counsel in a revocation proceeding. That's where Rule 32.1 comes in. And in this case, Mr. Walton was appointed counsel. He was represented by counsel at his initial hearings, and he chose to proceed pro se because he wanted to make the argument that he wanted to make. And I believe that the court did not abuse its discretion in allowing the defendant to represent himself. As far as the third issue, which was whether the court had jurisdiction, I don't believe that Surratt applies because Surratt was addressing a case where a defendant was serving a sentence that was impacted by President Obama's grant of clemency.
Don't we only have to look at the plain language of the commutation to know that it doesn't apply?
Correct, that's my argument, yes, Your Honor. So, unless the court has any other questions.
Ms. Conklin, you don't get a chance to come back up, so I want to be fair to you. Make sure you've given me all of your arguments in response to Mr. Leary's. And make sure, if you have, then you can say, I've done. I want to make sure, because you don't come back. I think fairness is always important. But getting back to the grade A, which you just conceded that he preserved that because he objected to that, correct?
The Kansas, yes, Your Honor.
Right. So, you're familiar with Campbell case, right? Are you
I'm sorry,
United States versus Campbell case? Are you familiar with that?
I believe so, Your Honor. I'm just flipping through my notes on my cases.
Well, that's okay. If you're not, we'll move on. I'll make sure in terms of, we're talking about West Virginia, because there are two. One is Kansas and West Virginia. It says distribute marijuana under West Virginia law. The question is that a controlled substance offense for the purposes of analysis for a grade A violation, right? You have to run that through whether or not. You can't just, it's marijuana, it's controlled. No, we have to do that, right?
No, you're not correct. And it has to be something that's punishable by more than a year.
Okay, do you agree that likely, we don't know exactly, likely was West Virginia Code Section 68-4-401, paren A, stating it's unlawful for any person to manufacture, deliver, or possess with intent to manufacture, deliver a controlled substance? You think that very likely was what probably that charge related to? You agree with that?
The felony, possession with intent to distribute, Your Honor, yes.
You agree with that, right? So don't we have to determine whether or not, in fact, then that statute, that vow would qualify, correct?
Yes, Your Honor.
All right. Now, didn't we say in the sense that that's not necessarily so? Because it's in court, we have to do a categorical analysis, right? Don't we have to do that, whether or not it fits categorically? Right? Isn't that the next step?
I believe so, Your Honor, But the question is it a felony or a misdemeanor?
No, it's more than that in terms of, it's the question whether or not is that charge itself falls into what is indeed, for the purposes of determining a grade A, whether or not it qualifies, right?
Yes, Your Honor.
Right, so tell me why that under Campbell, when we say that West Virginia offense is not a controlled substance offense, because it has inchoate type inclusion, that's why categorically it doesn't match, because we have to look at the least culpable offense that could have been charged under that, right? So tell me how it meets the categorical analysis for inclusion.
Your Honor, I do not have the West Virginia statute in front of me. I don't have it to look at it and to break it down and.
That's important, isn't it? Because the record, the district court didn't do any of this at all, so we have to do our own homework for that. And when you run through the analysis, if you don't have any response to that, that's fine. I want to make sure I don't want to leave you.
No, Your
So you
Honor.
haven't done that analysis in terms of the Campbell?
No, Your Honor, but I would also submit to
Did the
the court.
defendant do that analysis? I don't remember seeing that in
No,
his
he
brief.
didn't. He did not
On
dispute the
appeal
West Virginia.
Or in the district court?
Yeah, but we have to construe the law, don't we? He preserved it.
Did he
It's
preserve it
what's-
in the district court or on appeal?
I don't believe he preserved that, Your Honor.
What you did say, he objected to the grade A.
Kansas, for the
I'm sorry,
Kansas.
Just Kansas.
Just Kansas, Your Honor. It was my impression that it was just Kansas, that he was saying the Kansas statute. That's all.
But it's still plain, I think this might need plain error.
Did he raise it in his appellate brief?
No.
Like I said, I think it needs plain error.
Do we review for plain error things that aren't raised in an appellate brief?
I don't believe so, Your Honor. If there are no further questions, I'll go ahead and see the rest of my time. Thank you.
I thought I did raise the issue about the
About
grade.
Campbell
I didn't specifically talk about Campbell.
and whether it qualifies under the federal definition?
I just had an oops moment when Judge Gregory was asking her about Campbell, because I think Campbell would come into play.
Absolutely.
But you didn't raise that in your brief, did you?
I didn't raise specifically Campbell, but
In
I
your
do-
brief, you said, this might have been a different West Virginia provision, could have been just possession. That was your argument, could have been less than a year.
Correct.
Right, I
That-
just read your brief again, because I wanted to make sure I understood what your
You're
argument was.
absolutely correct, Your Honor, that's right. That was the argument. I didn't even think about the Campbell argument, because as this court has held in Campbell, that is categorically not a controlled substance offense, which brings us back to the procedural error, which is this all could have been avoided had the district court in the first instance considered the Chapter 7 policy statements, assessed a violation grade, established the advisory guideline range, and then explained the sentence. So,
If it's not been briefed, if you didn't raise it in your brief and the government did get a chance to respond, on appeal, we're not at liberty to come up with our own interesting questions, are we?
fair enough.
All right.
I agree. I think the
But
only
the
other thing.
the law is always an interesting subject.
I
And
agree.
that, right, when you raised the question about whether or not, you raised the question of whether or not, in fact, this would qualify in West Virginia, right?
I did.
I don't think you have to cite a specific Supreme Court case necessarily. The whole issue is before it.
Well-
It's not one of those Simon Says situation, you didn't say, got to go back because you didn't say Simon Says. The question is about the law, and we construe the law. And you did raise the question, but you didn't say Campbell, but you questioned that.
I question both grade A violations, that's
Exactly.
correct.
You did.
With regard to Ms. Conklin's discussion about clicking through the factors, that is correct, and this court has held that there's not a high standard for the district court to explain the sentence that it imposed. It doesn't have to get into a lengthy discussion as to why. It only has to acknowledge these were the reasons so that it can be appropriate appellate court review. The court in this case didn't do any of that. So I would submit it's not procedurally reasonable for that reason. And I'd be happy to answer any other questions. That was the only thing I wanted to bring up on rebuttal.
All right,
Thank you.
thank you. Right. We'll ask the clerk to adjourn the court, Sunday die, and then we'll come down and greet counsel.
This honorable court stands adjourned, signing die. God save the United States and